Thank you very much indeed, Mr. Chairman. I rise to speak in favour of Amendments 35 and 37 and new Clause 6, tabled in the name of the Shadow Home Secretary and myself. But may I just start by reminding the House and anyone watching at home that the Labour Party is opposed to this bill in its entirety, for the simple reason that we are opposed to the Rwanda scheme in its entirety. We have been absolutely clear that we need to stop the Conservative small boats chaos, and we need to fix our broken asylum system. But those aims can only be achieved by way of measures that are based on common sense, hard graft and international cooperation, as opposed to headline chasing and government by gimmick from the benches opposite. Now, the benches opposite like to accuse us of opposing everything that the government is doing to stop the Tory small boats chaos, but that is simply not the case. We on these benches fully support measures such as the deal with Albania, because that is the sort of sensible, pragmatic action that can make a tangible difference. And we've repeatedly made our support for this course of action crystal clear, if only the benches opposite would care to listen. But the Labour Party will never support any proposal that is unaffordable, unworkable or unlawful. And Mr. Chairman, I will give way.
Honourable friend for giving way, and would he agree with me that the government is being extremely neglectful with the public purse by throwing money at the Rwanda scheme that simply will not work?
Well, my honourable friend is absolutely right. It's quite remarkable that a party that used to pride itself on being the party of fiscal rectitude is throwing £400 million of taxpayers' money at the government of Rwanda for precisely nothing. The only thing they've got so far is they've sent 3 Home Secretaries to Rwanda, but not a single asylum seeker. £100 million and Mr. Chair, the Rwanda plan is all of the above. It is unaffordable, it is unworkable, and it is unlawful. It's unaffordable to the British taxpayer because a truly staggering £400 million of our taxpayers' money is on the way to the Rwandan government without a single asylum seeker landing in Rwanda. It's unworkable because we know that the Rwandan authorities are only capable of less than 1% of the 30,000 who crossed the channel in small boats in 2023, according to the Court of Appeal. In order for a deterrent to be effective, it has to be credible. And surely even the most ardent supporter of this policy would acknowledge that such a tiny chance of being sent to Rwanda is ever going to deter someone who has risked life and limb to cross continents to escape from persecution and violence.
I thank you for giving way. The Foreign Office recently admitted that hundreds of Afghans eligible for resettlement have not been brought into the UK. They exemplify the need for safe and legal routes. And is it not the case that those are exactly the people who are risking life and limb because they cannot get the legal and safe routes that the government should provide?
Yeah.
Well, the Honourable Lady is right, and a case in point, of course, is the Afghan schemes. The Arab scheme has more or less collapsed. The ACRS is not working at all. And which nationality is always in the top 2 or 3 to be crossing on the small boats? The Afghans. It's pretty straightforward. So we oppose the Rwanda policy because it's not a deterrent, it's a distraction. Far better, as the Shadow Home Secretary and myself and others have set out many times in this chamber, to redirect the vast quantities of taxpayers' money that are being wasted on the Rwanda scheme into a new cross-border police unit and into a new security partnership with Europol, which can smash the criminal smuggler gangs upstream. I will give way.
I'm very grateful. I think he's making a really important point about how we need to be cooperating much more intensively with the law enforcement agencies across Europe. The brutal fact is this: these gangs are putting people into boats that were made for rivers, not sea, in treacherous conditions. I mean, who in their right mind would go in one of those dinghies in the English Channel right now? But people are being forced to do that by these gangs. We need to smash the gangs, and we can only do that by working with our colleagues across Europe to make sure that we bring this to an end.
My honourable friend is absolutely right, and if we accept that international cooperation with our European partners and allies has to be at the heart of the dealing with the gangs as he so eloquently sets out, that the possibility of that cooperation is fundamentally undermined when we have a government that is flagrantly prepared to break international law, which should underpin the trust that is a prerequisite for all of this cooperation to happen. So this cooperation based on joint working and intelligence sharing with our partners and allies is only possible if Britain is deemed to be a trustworthy partner. And that brings me to the third reason for us opposing the legislation that's before us today and for opposing the amendments that have been tabled by so many on the benches opposite. Because, Mr. Chair, we find ourselves in an utterly extraordinary position. We find ourselves debating a government policy which has been found to be unlawful by the highest court in our land. Amendment 35, which I'll come to shortly, reflects that very fact. And we find ourselves confronted by a government that is seeking to legislate for an alternative reality. Because whilst ministers appear to believe that they can pass a bill which determines that the sky is green and the grass is blue, that does not make it so. I will give way.
Has it escaped the honourable gentleman's notice that there was one claim that was dismissed by the Supreme Court judgment on Rwanda, and that was in Iraqi, the case of ASM. And the reason for it is very simple, and the court made this crystal clear in paragraph 144 of its judgment, that the issue in question was undermined, as far as that claimant was concerned, by clear and unambiguous words in an Act of Parliament. In other words, the sovereignty of Parliament prevailed.
I thank the honourable gentleman for his comments, but the point with the sovereignty of Parliament, of course, Parliament is sovereign. And of course, we in this place are sent here to make laws. But we must make those laws with restraint. We must make those laws whilst respecting the judicial function. The separation of powers is fundamental to our identity as a liberal democracy. So whilst he does very often talk about the sovereignty of Parliament, it is absolutely vital that his comments must always be founded on the principle of the checks and balances that the separation of powers gives us. I will give way.
Well, Tim, just to tease out a little bit more what Labour policy is on that specific issue that he referred to, is he ruling out any consideration of this House determining to overturn the wrongful convictions of hundreds of sub-postmasters simply because that would be setting a new precedent in the relationship between this House and the courts?
Well, that's an interesting one. I didn't have it on my bingo card today to be talking about the sub-postmasters scandal. Look, Parliament is free to legislate in any way that it wishes, but it has to do so taking full recognition of the view of the courts. And I note that a number of eminent legal experts have raised some concerns about the government's proposed approach on the sub-postmasters. We have to see precisely how the detail of that looks, and it is our duty in this Parliament to scrutinise that very carefully and to ensure that we're not setting dangerous precedents. What I would argue is there is no doubt whatsoever that the bill before us today is a deeply dangerous, profoundly dangerous precedent because it seeks to directly overturn the findings of the highest court in our land. And I would argue that that is a toxic approach, Mr. Chair. I'll give way to this.
Very grateful to the Shadow Minister for giving way. Has he not seen all the comments and budget lines that this government has put out, stating that it is cooperating extensively and fully with continental countries over trying to crack down on this awful trade which is leading to deaths in these small boats, and that the proof of that is that money is sent to France in order to help them with their tasks, and there is no evidence that they're not cooperating?
I thank the honourable gentleman for his comments. The cooperation with France is to be welcomed. The problem with it is it's too far downstream. What we need to see is far better cooperation upstream, which is about sharing data, fixing the issue with the databases. My right honourable friend, the Shadow Home Secretary and the Leader of the Opposition visited Europol recently to come forward with very practical and detailed plans around getting the data sharing right. And that may actually then address the issue that the number of prosecutions of criminal smuggler gangs is going down on this government's watch. The number of returns and removals has gone down by 50% since 2010. So I think it's, again, we go back to this point about let's put more energy and resources into the pragmatic, sensible things that can actually make a difference, as opposed to being distracted by this madcap Rwanda scheme. So, Mr. Chair, it's a mark. I will, if I could just make a little bit of progress. Mr. Chair, it is a mark of a liberal democracy that courts are independent of Parliament and the executive. And we on these benches believe passionately that this separation of powers is a fundamental and immutable element of what makes us proud to be British. So we on these benches are not only opposed to the specifics of this bill, Mr. Chair, we are also deeply troubled by what it represents in a broader sense. And I will give way.
Christmas period, the Labour front bench anonymously briefed The Times to say that they would want to pursue an offshore processing model. Is that correct, that it is his position and that of the Shadow Home Secretary? And if so, why would they want to do something which is known to be more expensive and less effective, because you have to bring everyone back to the United Kingdom one way or another, and so you create no deterrent whatsoever, but one wouldn't want to move forward with a scheme like Rwanda?
Well, I thank the former immigration minister for his comments, and I must say I did enjoy opposing him and working with him on some occasions, and I thank him for his comments. What I would say is that if you look at the Ukraine scheme, that is an example of offshore processing. Those applications were processed in Poland before they came to our country. Look at the Hong Kong scheme. There are plenty of ways of doing upstream processing, offshore processing, and to coin a phrase, what matters is what works. And what is absolutely clear is this Rwanda, and it's difficult to imagine any scheme that could be more expensive than this one. But I'm going to make some progress. What I would cite is the view of the Bingham Centre for the Rule of Law and countless other legal experts who have stated that this bill is contrary to the rule of law because it amounts to a legislative usurpation of the judicial function. It is an assault on our country's constitutional conventions, which require the legislature to respect the essence of the judicial function. Moreover, there is a staggering hypocrisy at the heart of this bill when you consider it in the context of the treaty that has been signed with Rwanda. Because the purpose of that treaty is to bind the Rwandan government into respecting the rule of law, and in particular the principle of non-refoulement. But how on earth can ministers hold the Rwandan authorities to account on these matters if they themselves are so blatantly and egregiously failing to practice what they preach?
The Honourable Gentleman, it is a little disingenuous to liken the Ukrainian scheme. The only criteria for the Ukrainian scheme is you had to be Ukrainian and come from Ukraine. He just mentioned enforcement, and he said that it had gone down. So up to the end of November 2023, Home Office Immigration Enforcement arrested over 246 people for people smuggling into the UK, and there were 124 convictions. And that is in addition to those arrests and convictions which have happened in the continent. So on what figures that he's just claimed were those figures a decline?
There's been a 30% drop since 2010 in the convictions of criminal smuggler gangs, and there has been a 50% drop since 2010 in removals. I'd be very happy to write to the honourable gentleman with the clear details of that fact. We've got the receipts. So, Mr. Chair, it is against this fundamentally flawed and farcical backdrop that we seek to modify the legislation that is before us today. Our amendments are an attempt at damage limitation, an effort to moderate the most egregious aspects of this nonsensical and counterproductive bill. Our Amendment 35 acknowledges that, in November of last year, the Supreme Court upheld the Court of Appeal judgment. It ruled unanimously that the Rwanda policy was unlawful because there were substantial grounds to believe people transferred there could be sent to countries where they'd face persecution or inhumane treatment if Rwanda rejected their asylum claims, a practice known as refoulement. The reason for these concerns relate to an issue that I first raised at this dispatch box back in April 2022, when the Rwanda plan was first announced. And that is the fact that when Israel signed its deal with Rwanda in 2013, many of the asylum seekers who were sent from Israel to Rwanda were routinely moved clandestinely to Uganda. And in 3 cases, refoulement to Eritrea via Kenya was only prevented by the UNHCR intervening. Little wonder that the Israeli Supreme Court ruled the scheme unlawful in 2018 and it was closed down. In December, the government signed a treaty with the Rwandan government which says that refoulement is prohibited and says anyone removed to Rwanda from the UK must be allowed to stay in Rwanda. Indeed, the only country to which people can be transferred from Rwanda is the UK, which under the deal must also accept some of Rwanda's most vulnerable refugees and offenders sent back from the country. This fact in itself tells a story, Mr. Chair. The fact that the UK government and the Rwandan government have agreed that Britain might need to take some Rwandan refugees is a stark admission of the fact that Rwanda is not a safe country for many people. Indeed, since the first £120 million payment by the British government to Rwanda, 6 Rwandans have been granted safety and refuge in the UK. And then there is the tragic fact that ministers are simply too afraid to address that in 2018, 12 Congolese refugees were shot dead by Rwandan police for protesting against food shortages. Mr. Chair, our Amendment 35 therefore permits British courts and tribunals to recognise and deal with the specific risks of refoulement associated with Rwanda by removing the relevant text in Clause 2 of this bill. Likewise, our Amendment 37 makes it clear that decision makers must be able to take the risk of refoulement into consideration when processing asylum claims. The bill designates Rwanda as a safe country and therefore makes clear that every decision maker must conclusively treat the Republic of Rwanda as such. It states that the bill does not permit a decision maker to consider any matter, claim or complaint to the extent that it relates to the issue of whether the Republic of Rwanda will or may remove or send the person in question to another state in contravention of any of its international obligations, including in particular its obligations under the Refugee Convention. Yet, as the government has previously acknowledged, the facts on the ground can change, and therefore it must be acknowledged that decision makers should be able to make their own judgments based on the latest court rulings. So we see no reason not to let decision makers do their jobs and make decisions based on all the knowledge available to them as the situation evolves, as opposed to the frankly absurd idea that Rwanda can be defined as safe in perpetuity. I turn now to our new Clause 6. The new treaty states that Rwanda is committed to addressing concerns that are laid out in the Supreme Court judgment, including refoulement. New Clause 6 would simply help to ensure that Rwanda can be held accountable on its treaty commitments by placing the monitoring committee for the Rwanda Treaty on a statutory basis and by placing conditions on when the classification of Rwanda as safe can be suspended in accordance with the material conditions and or non-compliance with obligations under the Rwanda Treaty. As things stand, the government could vary the operating principles of the Monitoring Committee without it being possible for such changes to be challenged in our domestic courts. Our new Clause 6 therefore addresses this unacceptable position by placing the Monitoring Committee on a statutory footing, thus making it justiciable and thus, by definition, more transparent and more accountable. We see no reason why members opposite and across this House should oppose the principles of transparency and accountability upon which our new Clause 6 is based, and we hope they will join us in the I lobby later. Turning briefly to the amendments put forward by members opposite, I would point out that even one of their own colleagues, the chair of, I believe it's called the One Nation Group, has described many of these amendments as authoritarian and a betrayal of conservative values. And he's right, Mr. Chair. The bill in its current form is already an assault on our reputation as a country that upholds the separation of powers and the rule of law. And the majority of the amendments tabled by the benches opposite would take us even further away from those basic democratic principles. So let me be clear. We on these benches will be proudly voting against the amendments that are being promoted by the benches opposite, because the government's Rwanda policy is unaffordable, unworkable and unlawful, because this bill is an affront to the values that we hold dear, and because we will always stand up for the separation of powers, for the rule of law, and for ensuring that we can stand tall in the world.
He's very kind to give way a second time. I've listened to him carefully, and I don't have an answer to one of the central questions of the debate. Is the government's view that Rwanda is a safe country? What is the view of the Labour Party? Is Rwanda a safe country? I think we would all be interested to know, and I know the government of Rwanda would be interested to know the Labour Party's position.
Well, I thank the honourable member for that intervention. I don't think I could have made it any more clear that we believe in the rule of law and in the judicial function. And when the Supreme Court of our land rules that it is not safe to send asylum seekers to Rwanda, we on these benches agree absolutely with that position. Mr. Chair, we've seen some pretty bizarre stuff emanating from the benches opposite over the decades. But when the history books of the last 14 years are written, their psychodramas over this Rwanda policy will surely take centre stage. Just think of the astonishing amount of government time that's been ploughed into this unaffordable and unworkable nonsense, when ministers and officials could have been focused on the design and delivery of the sort of sensible, practical measures that I mentioned earlier. And just think of the vast amounts of political capital that the Prime Minister has squandered on a policy that he doesn't actually believe in, and that his Home Secretary has privately poo-pooed, if you'll pardon the pun, Mr. Chair, and that has left his leadership in tatters. The legislation before us is a sham. But in the interest of damage limitation, I urge members to get behind Labour's amendments today. And of course, most crucially, I urge members to vote down this bill at third reading and get behind Labour's plan to deliver the security partnership, the cross-border police unit that will smash these criminal gangs and defeat the people smugglers and will stop the Tory boats chaos once and for all.
Briefly turn to new clause 6 tabled by honourable members opposite. I was intrigued to hear the Shadow Minister state that the purpose of this clause is to invite further legal challenge. That seems to be, Dame Rosie, Labour's plan, to invite further legal challenge. That's the purpose of new clause being tabled. That is the exact opposite purpose that those on this side of the House have. We want this to work. Yes, of course.
Simply misrepresenting the purpose of that new clause 6 is to put the monitoring committee on a statutory basis so that it can potentially be subject to our own domestic courts. I don't know whether he thinks our domestic courts should be lower down the pecking order than the courts of Rwanda.
I'm grateful to him for his intervention. When he was setting the policy out, in his opening he said it will invite further legal challenges. Those on this side want to shut out legal challenges. Those on the side opposite want to encourage further legal challenges. Dame Rosie, the government has delivered a plan for immigration that will work. This builds upon the excellent work of my right honourable friend, the member for Witham, the champion of the Nationality and Borders Act 2022. It builds on the work of my predecessors, my right honourable friends, the members for Newark and for Fareham, who worked incredibly hard to deliver the long-awaited Illegal Migration Act, the toughest piece of immigration legislation until this piece of immigration. Just look at Albania. Dame Rosie, our successful deal with Albania started with small numbers, has now removed nearly 6,000 people with no right to be there. We know that the deterrence has worked because small boat arrivals from Albania are down by 94%. Legal challenges have not successfully stopped the flights to Albania. Flights have not been stopped. In fact, not a single case of Albanian small boat arrivals has reached a substantive hearing at the upper tribunal in the past year. Those on this side of the House are united in our determination to make sure this bill works. As drafted, it creates an ever tighter test that illegal migrants face removals to than they face removals to Albania. Our Rwanda bill is tougher, tighter, it goes further. We have a plan to stop the boats, and I invite honourable members to back it.